Okay, welcome everyone to the 2023 update for student loans and bankruptcy. I'm Tara Salinas, one of your hosts and panelists, and I also have Karen Cody Hopkins here with us. We're going to go through primarily the slides today, but I wanted to let everyone know that you should have received an email just about a half an hour ago with all the materials. They're also available in the chat for this webinar, as well as a link to our evaluation and the information about how to claim your CLE credit today. So again, thank you all for signing up and for joining us. For those of you who have already heard from the listserv, I just want to say a special thank you to our friend Andy Cameron, who's no longer with us. He was always one of my favorite CLE attendees because he would come into the CLE, pick up his credit application and walk back out the door. He certainly didn't need to hear anything from us about bankruptcy. He was an expert and he will be sorely missed. Karen, do you want to introduce yourself really quick and we'll get started?
Sure. I think most people know me. My headshot's a little outdated, but I've been doing student loan work since 2006. I do want to tell people, please do not ignore the materials that Tara sent you. She did most of them, and I was blown away at how good they are. You do not want to do this, just come into the CLE, look at our slides, and stop. You really want to look at those materials, and you're going to want to refer to them again as you learn more and more through us and your clients about student loans. So they're just fabulous. So don't put those in some hidden folder.
Thank you, Karen. That's very kind. We're going to start today talking a little bit about kind of what has already happened and what's coming up. I just want to give everybody a heads up. You can ask questions in the chat. So if you've got a question, please just pop it into the chat and I'll monitor that and we'll go forward from there. We're going to start today with the Supreme Court update. I think most of you know that there really isn't an update. In August of 2022, nearly a year ago, President Biden announced a plan to provide debt relief for student loan borrowers. Department of Education was proposing $20,000 of student loan forgiveness for Pell Grant recipients, up to $10,000 in debt cancellation for non-Pell Grant recipients. There were some income restrictions, et cetera. We were estimating about 45 million borrowers would have been impacted. Within about a month, there were multiple lawsuits filed. By October, the Eighth Circuit had given temporary emergency orders blocking the forgiveness plan. And by early November, the Department of Education stopped accepting applications for this cancellation of debt. All the way up to December 1st, the Supreme Court finally agrees to hear arguments in cases brought by 6 states. And the Department of Education asked the Supreme Court to reverse the block on the program set by the Eighth Circuit. The arguments were held in March, and then the ruling was released in June. In a 6-3 decision, the court ruled that the Biden administration's plan to forgive nearly $400 billion in student loan debt was an overstep. The majority used the 2003 HEROES Act, claiming that while it did give the Secretary of Education the power to waive or modify student loan obligations, the major questions doctrine prevented the federal government, Department of Education specifically, from implementing this policy change without approval from Congress. Justice Kagan wrote a scathing dissent, and in a departure from common practice, actually summarized her dissent from the bench. It's pretty bold. I think the dissent really stressed that the majority had departed from what she called the demands of judicial restraint. Immediately after that, the Biden administration held a press conference and said, hey, we're going to come up with a new forgiveness program under the HEA. The problem with that new program is that it's still subject to rulemaking, and so that negotiated rulemaking process can take some time. We are going to keep our eyes open and we'll certainly update you about what's coming. Of course, we do anticipate that there will be further legal challenges to that new program. The great news is that there are already amazing programs available that offer relief options for a lot of debtors, many of these student loan borrowers. So I think we're in good shape there. If you are like I was when I started learning about student loans, it can feel very confusing And so I have to say that Karen has always done an excellent job explaining this and taught me everything I know about student loan law. So I want to let her take over here and talk about student loan basics.
Okay, so we have to talk about what kinds of student loans you have. You have to remember that right now, student loan forgiveness has left a sour taste in people's minds because they didn't get it. And now they're coming up to repayment that's starting this October, and there's a lot of stress and horrible confusion. And you have to start at the what kind of student loans do people have? And usually asking them won't get you an answer because most people don't understand what student loans they have, and they can't tell you with any clarity. So you have to learn to assess student loans enough to make decisions to help them with their bankruptcy and perhaps their student loans just in general. So I always ask first, do you have federal or private or something unusual or both? They can't tell me, so I have to go find out. What they will always tell me is 90% of them will say something about Navient, which has had its fingers in almost every student loan pie. And they will tell us that the department sold their loans to Navient while the department never sells federal loans. But the structure of federal loans is horribly confusing. So starting asking them about their federal loan, and do they know if they have them? And also be sure at the same time to ask them if they have private student loans. Now, one almost immediate hint that someone has some private loans is federal loans don't have cosigners. So the loans that have cosigners are almost 99.9% private. Okay. So if we can go to, so the place to start is the Department of Education has a student aid website for its section called Federal Student Aid, which is known as FSA. The website, studentaid.gov, is the place your client's loans are listed with many details. Some of you who have been practicing for a while may have heard this called the NSLDS. That is outdated terminology. It's not being used the way it used to be. The database probably feeds what we now see on studentaid.gov, but a person to find out about their federal loans has to log in to studentaid.gov. And each person has a unique account. And it is illegal for you to go in with your client's ID and password to go look at the site. So the very first thing you want to do with a new client is have them go in and check to see, do they have any loans at studentaid.gov? It's important to understand they're going to have to log in. Most of them won't remember if they've ever been there. There's an explanation about how to log in if you don't remember your ID or your password. If you've never been there, it can take up to 3 days. But if we can go on, we'll see that.
I'm going to pause for just a second, Karen.
Sure.
Could somebody post in the chat if they can see the slides that we're going through here? I'm getting a few messages that maybe you can't. Can anyone else not see? Sorry for the pause as we go through technical difficulties. Yep. Oh, people can see them. Okay, great. Thanks all.
Okay.
One more. There we go.
Okay. So studentaid.gov is going to be the major source for starting, but it doesn't have a tutorial. It doesn't have anything to really explain what the person's going to get. So you have to give them instructions on how to go in, and you do not, you're going to have to help them, although you can't log in yourself. Now, each person who has a loan will have their own account. And there's a great deal of confusion about federal Parent Plus loans. The parent with the Parent Plus loan will have their own account. So they will need to log in themselves. Students are not supposed to be going into the parent's account. Sometimes parents will say, well, I took out the loan, but the kid's paying it. It doesn't matter to studentaid.gov. The parent has an account. The kid, if they have federal student loans, has an account. And really confusing to some clients is that because the government is trying to automate the system, to get people's tax income information. And because many people file joint returns, and the government, being the government, has to have permission to look at those tax returns if the people are married, then in some cases, spouses, even if they have no federal loans, have to set up an account so that they can go in and give permission for the IRS data to be shared. But this is scary to people because they think they're taking on responsibility for paying the loans. They're not. They're just giving an okay to share the income tax data. So the student has to have an account. The parent with a Parent Plus loan would have their own account. And sometimes spouses will be asked to create an account even if they have no federal student loans. Okay, this is the most important basic piece. If you get this, you'll be so happy. Well, you have to understand the types of federal student loans because each loan has its own set of rules and forgiveness programs and things you need to know, and your clients will know none of this. So let's talk about the different types of loan types so that the terms become comfortable to you. Since 2010 for sure, and in some cases earlier, the major federal loans are direct loans and their cousin, direct consolidation loans. Those are the most common, the most flexible, the least problematic. Now, they have relatives that are called graduate plus loans and parent plus loans. We'll come back to those a little bit more. Now, there's been a great deal of confusion because before 2010, when Obama said the government is going to lend the money, there was a system of federal student loans that were set up where the government controlled the programs, but the money was lent by lenders, commercial lenders. There was a guarantor for the loan, and then there was a servicer. And since Navient did many of those things, that's why they seem to be in everybody's portfolio. Now, over the years, the Department of Education has, because of default, taken over a lot of the FFELs. So now you have FFELs owned by the Department of Education, and you have FFELs and FFEL consolidated loans not owned by the Department of Education. They're called commercially held, or FFELs not owned by the department. And there was quite a bit of publicity around the Biden forgiveness because originally the department said that people had FFEL loans not owned by the Department of Education could do a simple consolidation, and then they would be eligible for the forgiveness. But when they got sued, the department said, oh dear, we can't do that anymore. So if you have FFELs that have not been consolidated into a direct loan, we're not going to be able to give you forgiveness. And so all of a sudden, the term commercially owned FFELs came into the vocabulary, but still most of the borrowers don't understand any of this at all. But FFEL loans not owned by the department have many limitations as to what can be done about them. So most student loan lawyers today are saying to every client we have, you really should consolidate those out of FFEL world to become direct consolidation loans. Well, okay, and that's not a very complicated process. You can do it online, but you have 30 years of people being told, oh, if you consolidate, you're going to lose your payment count for forgiveness under the old programs. So a lot of the older borrowers got it drilled into their head, oh, you shouldn't consolidate. The world has changed. They need to be convinced to consolidate. It is the best thing they can do for these old loans. There are also some other types of loans. There are Stafford loans that are older than all the ones we've talked about. There are Perkins loans given out by universities, which they can sometimes become owned by the department as they default. And then in the box down there with all the abbreviations are a whole bunch of other kinds of loans that are pretty rare, but they do exist and they are federal loans. But this slide is something you need to know. Now, another reason for, we'll talk more about this as we go along. It's okay to go to the next one. So the other confusion is people don't understand servicers. So the Department of Education sets the rules. They own a lot of the loans, but they don't have the personnel to collect the money from 45 million people. So over the years, they have had a series, some horrible, some good, and some bad, of servicers. They are basically the loan collectors for the Department of Education and the policy, and they're supposed to carry out the policies of the department. Now, there have been a lot of servicers over the years. Right now, the key servicers that you would need to know about would be MOHELA. And MOHELA gets a great deal of attention. First of all, the Missouri's government sued in MOHELA's name as part of the Supreme Court situation, even though MOHELA itself did not sue the Department of Education. They're perfectly happy to be a servicer. Anyway, they took on the role of servicing the Public Service Loan Forgiveness Program. And we'll talk about that later. But MOHELA is one servicer, and anybody who has anything or any possibility of getting any forgiveness through the Public Service Loan Forgiveness should be steered and should sign up for MOHELA as their servicer when possible. When you consolidate, you can pick a servicer. Other times you don't get to pick and you'll just get assigned a servicer. Now the other current servicers, Aidvantage, it is not Navient, but it looks like Navient's old things because it essentially took over a number of the templates that Navient had been using. And right now, if there are loans owned by the department, then Aidvantage services them. Then there's also Nelnet, which bought Great Lakes, which used to be a servicer. Then there's Ed Financial and OSLA. I hardly ever see OSLA, Ed Financial, not as many. Nelnet's big and Aidvantage. So there's also, Navient still services those commercially owned FFELs, and they service private loans. And so they still come into the conversation, and people still constantly tell you that either Sallie Mae, which spun off Navient, or Navient owns their loans, services their loans, controls their loans. It's just, Navient's just a point of huge confusion. And there's a couple of other places like Aspire and some other debt collectors and things, but the federal. So let's talk about the cycle of how somebody gets a loan. The loan is dispersed. It's in good standing while you're in school and for the 6 months after graduation. But then 6 months after you graduate, you're supposed to start into repayment. And there are two major groups of repayment plans: standard time-based plans and income-driven plans. When I started in 2006, there was only one IDR. We're now up to 5, I think. And there's a couple
Soon to be back to 3.
We're going to be back to 3, yeah. Now, supposing somebody has graduated school, they've entered repayment, and oops, they can't make the payments for whatever reason. There are temporary solutions, deferments, and forbearances, and we'll talk more about those a little bit later. And now, what happens if you can't make your payments and you don't make your payments? Well, if you're delinquent, that's the first 269 days that you're late. And not much happens if you're late, except you get the normal collection type calls from the servicer going, "You pay your bill." If you hit either 270 for most loans, or a few loans go up to 360, you go into default. And we'll talk more about that. But default would lead to either collection or cure. Now, default, which is also acceleration in the debt collection world, there are a couple of things that happen. So they'll start with just normal calls and collection activity. And there were millions of people that were in default when COVID hit. And when the department looked at this in the old days, if you were in collections and you didn't do anything, then they had remedies. So they had two remedies to get you out of default. They had a process called rehabilitation, which was a repayment plan process, and it's on hold at least through 2024. So I'm not going to talk a lot about it right now. Or you could consolidate your loans and get, in many cases, now again, there's lots of little asterisks to many of these things, but the general concept was you could consolidate your loans and then get back in good standing. Well, when the COVID pause or the COVID payment pause came in, the department looked at the I think it was at the time like 9 million people that were in default, and they decided they were going to have a blanket get out of default program. And they put rehabilitation on hold. You could still consolidate, but they announced a Fresh Start program, which we'll tell you more about later, that was just a fabulous way for people to get out of default and start over.
Hey, Karen, quick question. After
Yes.
default, is it correct that on acceleration, a 10-year statute of limitations applies?
Say that again?
We have a question. Somebody asks, after default, is it correct that on acceleration, a 10-year statute of limitations applies?
No, because there's no statute of limitation on collecting federal student loans.
Perfect. Okay.
It's a lifelong debt. Although if you die, they don't come after your estate.
There's a death forgiveness. Okay, go ahead.
Okay, so beginning in July of 2024, borrowers in default will have access to one of the existing income-based repayment plans, and so they can sign up for an income-based repayment plan, and that will allow them to get out of default. And if they can prove that they qualify for $0 repayment, because strangely enough, in the student loan world, you can have a $0 as your assigned monthly payment. It's a valid payment. It counts for things where they count payments. It's just a little unusual because it's actually zero. Anyway, they will be in good standing. And borrowers who have provided prior access to tax information and have not made a payment in at least 75 days or are already in default can automatically enroll. So they're building these on-ramps so that people aren't stuck in default for years, because the servicers did such a terrible job of advising people what to do about default and how to get out of it. And their goal is to just try to not have millions of people stuck in default for long periods of time.
Okay. Oops. Get to the next slide. So hopefully your borrower is not in default, because that's not where you want to be. Where you really want to be is repayment. So we're going to kind of talk about the different repayment options. Karen touched on it briefly, but there really are two main categories of repayment options. One is the time-based repayment. This includes the standard, the graduated, the extended graduated, and what's the fourth, Karen? Sorry. Extended and graduated. Okay, so there's standard, graduated, extended, and then graduated extended is kind of the combo fourth one. Those are all based on the assumption that the borrower will repay the loan in full. So it divides the loan up like a traditional loan into regular monthly payments. Some of the programs offer them staggered, and we'll talk about that, and some of them have a fixed payment amount the entire term. The other type of loan repayment is income-driven repayment, and we call that IDR. This usually requires an application and annual re-enrollment, but the new programs that are coming out are offering automatic renewal options. So we'll talk more about that shortly. Let's just go through the time-based repayment options. All borrowers are eligible for all three of these options. You can have FFEL loans, you can have direct loans, you can have Stafford loans, HEAL loans, Perkins loans, etc. The standard is going to set up a 10-year repayment for regular loans and a 10 to 30-year for consolidations. Borrowers will pay the lowest interest over time of these three options in the standard because it's usually the shortest period of time. The graduated starts a payment fairly low and then has a set increase in the monthly payment every 2 years. So you'll start your payment, say at $100. In 2 years, it'll go to $120, $140 in 4 years, etc. This is also structured on a 10-year repayment. Consolidation loans will have a 10 to 30-year repayment. The extended option allows repayment terms to be extended from 10 years to up to 25 years. And you can either do these as fixed, like a standard fixed payment, or a graduated payment. All borrowers are eligible, but in order to use the extended program, direct loan borrowers have to have at least $30,000 or more in debt. Again, the big factor with time-based repayment is that you're expecting to pay the entire balance. This is where a lot of people think they're going to end up until we tell them about income-driven repayment options. One of the biggest challenges we face as student loan lawyers or as lawyers who are advising people about student loans is to get people to stop thinking that they have to repay the full balance of the loan and to start them thinking about making a payment that's reasonable and affordable until they've satisfied the time commitment, not the dollar commitment of the loan. Like we said in just a few minutes ago, there are currently 5 repayment options. ICR is the only current option for Parent Plus borrowers. So anyone that has a Parent Plus loan is only eligible for ICR. It asks the borrower to pay 20% of their disposable income, and I'll go through how that calculation is made, for at least 25 years to get forgiveness. This is also available to other borrowers until July of 2024. After July of 2024, new borrowers will not be allowed to enter ICR. Only people who have Parent Plus loans can join that program. If you're already in it, you can stay there. Go ahead.
Kara, can I say one thing? It's really important to also know that oftentimes people in the old days would do a consolidation. And so there are people who have consolidated loans, and buried within that loan is a Parent Plus loan. Well, a Parent Plus loan is like, it like sticks to you. And if you have a Parent Plus loan, even if you consolidate, you can only have the ICR higher payment. And so oftentimes people were not told that it was not a good idea necessarily to put your Parent Pluses in with other loans. And that's why their payments are so high, even though they have a direct consolidation loan.
That's a really good point, Karen. So Parent Plus loans are kind of the kiss of death, honestly. I mean, if you take them out, you're not going to be able to repay on any of the income-based repayments except ICR, which is going to require the highest percentage of your disposable income. Disposable income is a term of art in the student loan world. The way that we calculate disposable income is taking your adjusted gross income and subtracting a percentage of the poverty index for your household size. Currently, that's 150% of the poverty index, but it's going to be moving as we start repayment now to 225% of the poverty index. So we take your adjusted gross income, subtract 225% of the poverty index, and then whatever's left over, take the percentages that are listed here. So 20% of the leftover in ICR, 10 to 15% in IBR. There are really 2 IBR programs. One is called New IBR and one is called IBR. This IBR is available to any loan holder except for Parent Plus. So FFELs are eligible here, Staffords are eligible. The advantage to IBR is that your payment will never be higher than what the standard repayment number will be. But that's a 10-year standard, not a 30-year consolidation standard. It's a 10-year repayment standard. So if you've got high income borrowers, this might be a place where they could end up and get some forgiveness, especially if their income has grown over time, rather than keeping them in a standard repayment program. Pay is about to sunset. I'm not going to go into the details of it because it's not really relevant. It will go away at the end of June or beginning of July 2024. Repay is a program similarly that is about to go away, not really go away, but transform into the new SAVE program. And the big key factor that we will mention multiple times throughout this program is that in order to be eligible for the benefits of the SAVE program, your loans must be direct loans. They can't be Parent Plus. They could be Graduate Plus. They can be direct. They can't be Stafford. They can't be FFEL. They can't be HEAL loans. They can't be Perkins loans. But you can get a direct loan by consolidating all those other types into a direct consolidation loan. If you're helping people with consolidation, make sure you're watching out for those Parent Plus loans. We don't want to consolidate those in with the rest, or they won't be able to get access to the SAVE program.
Kara, can I just say one
Again,
thing? I've been doing multiple consolidations every week for the last couple of months, because for people who can get out of the problems they have by converting to a direct consolidation loan, it's a very simple process, and then they're going to be eligible for SAVE. And the payment amounts for SAVE are very good for a lot of people. So doing a consolidation is something I can practically do in my sleep. I've done it so many times now.
I agree. And the application is very simple. We'll talk about that in a few minutes. But I want to go through some of the real features of the SAVE plan. Again, this is available to all direct loans except Parent Plus or Parent Plus consolidation loans, loans that contain a Parent Plus loan. Again, we're adjusting the amount of income that's exempt from being used for student loan payment from 150 to 225% of the poverty index. This is a great change. I love the next one. The Department of Education is going to eliminate 100% of interest on any loan that's in the SAVE program if the interest is not paid by the scheduled payment. So it's kind of like a little bit of a subsidy for this interest. The Department of Education doesn't want to have the ongoing problem that we've had in the past, which is I'm in an income-driven repayment, but I can't get, I'm feeling super discouraged because my loan has ballooned. All of a sudden I started with 25,000. I've been making my income-driven payment, and now they're saying I owe 40. I'm never going to get out of this loan. Well, people don't understand the forgiveness piece of this, but we're also now eliminating that potential for a loan ballooning because of compounded interest. Another really big factor here is that we're going to allow married borrowers to file separate taxes. If you file married filing separate, you will not have to include your spouse's income in the calculation for income-driven repayment. If I'm a young postgraduate and I marry someone who makes a lot of money, I don't want to have my student loan payment based on their income. And that used to be the case in all but one of the repayment programs. Now, all of the repayment programs will allow married borrowers to file separate taxes and still use only their own income for determination of their payment. That's a huge factor for a lot of people. Those are the things that are available for the SAVE program starting in October or September for October repayment. There are also some added features that will come about in July of 2024. The first one is that rather than using 10% of the borrower's discretionary income to calculate their payment, for anyone with undergraduate loans, The payment on undergraduate loans will only be 5% of discretionary income. That's a really huge change, because if you think about adding the 225% of the poverty index as exempt income, as well as reducing the percentage from 10 to 5, they will more than half the student loan payment for many, many borrowers. For undergraduates with an original principal balance of $12,000 or less, that's originally what they took out, not what their balance is when this starts. Their loans will be forgiven after 10 years of income-driven repayment. The department will then offer kind of a sliding scale of forgiveness. If you've got $13,000 in original principal balance, you'll be forgiven in 11 years, and $1,000 per year up to 20 years. Undergraduate loans will be forgiven after 20 years of repayment, which is the same as it is now. Graduate loans will still be charged 10% of discretionary income for the payment. Well, what about people who did both? People who have undergrad loans and grad loans? The Department of Education has the ability to calculate what percentage of your loan portfolio is undergrad and what percentage is graduate. You can actually see that on the Department of Education text files that we get. And that they will do a weighted average of those two to come up with the payment. Another big factor, and this has been huge, Karen talked about it earlier, we're not going to penalize borrowers for consolidating their loans any longer. It used to be when you consolidated your loan, you lost all your prior history of payment. So rather than benefit from public service loan forgiveness or income-driven forgiveness for your entire payment history, you would reset the payment history when you consolidated. They're not going to do that any longer. And then this is kind of a quirk of the SAVE program. After July 2024, if you make more than 60 payments under the SAVE program, you will not be permitted to switch to IBR. And I think the strategy here, and Karen, please feel free to jump in, but I think the strategy here is, if you're making 5 years worth of payments in SAVE, it's definitely the lowest payment available if you have a lower income, but there is no upper limit on the SAVE payment. So you could feasibly end up paying more in SAVE than a standard repayment number. And so IBR limits that payment number. So they want, if you're going to take advantage of SAVE, you got to stick with it the whole time. So even if your payment's going to go up. Is that your interpretation as well, Karen?
Well, I think that's true. They also, they have so many people fall out of these systems when things change, or they miss a renewal. What they're trying to do is put this stuff on an autopilot. You sign up, you give them the income information and the permission to get it in the future, and then they aren't chasing you as much for the annual recertification. And so I think the long-term goal is to better automate and simplify the system.
This is a somewhat old graphic. The Department of Ed put this out last year, but one of the things I like about it is it shows kind of some typical savings under the SAVE plan. These are once all the regulations are implemented, so beginning in July of 2024. Somebody making $38,000 a year is going to reduce their payment from $147 to $31 a month. Someone making $77,000 a year with 2 kids, married with 2 kids, is going to reduce their payment from $295 to $61 a month. These are huge annual savings for middle and low income borrowers. Looks like we've got a question. Are loans of more than $20,000 still forgiven after 20 years in SAVE? That's correct. Undergraduate loans of more than $20,000 are still only 20 years. So the whole loan, not just the $20,000. I think this might be the biggest news that anyone could provide. This should be the biggest takeaway for bankruptcy practitioners. There is a bankruptcy-related IDR change that will be effective July 1st of 2024. The regulations will award credit towards income-driven forgiveness for months where the secretary determines the borrower has made payments under an approved bankruptcy plan. This means that Chapter 13 borrowers should be getting IDR credit for up to 60 months that they're in a Chapter 13 plan. There are a couple of restrictions. They only get credit for months that they fulfill their plan obligations. So if you don't make your plan payment, you don't get credit. And it will require the trustees to notify the Department of Payments after distribution's been made. I'm interested to see the full kind of how this program gets implemented. But we have included in the materials the Buchanan language, which allows Chapter 13 debtors to continue in their IDR program and get credit during a bankruptcy case. This new regulation will eliminate the need for that Buchanan language and should simplify because it doesn't indicate that the borrower has to pay student loans under the plan, just that they made payments under the plan, which to me and many others translates to if you make your Chapter 13 plan payments, you get IDR credit, which is, I think, phenomenal.
Right, this is Karen. I will mention this has been announced in some published regulations. Virtually nobody knows about it yet, and there could be many changes to it. But before, for those of you who don't know, if somebody filed a bankruptcy, they got put in an immediate bankruptcy forbearance, assuming that the noticing to the department and the servicers was even correct. So it would just be sitting there for a Chapter 7 term or the 5 years of a bankruptcy, and interest would grow on the loans and they would get no credit of any kind. The trustee might make a payment and that little baby payment might be applied, but they were stuck in a forbearance where they couldn't take advantage of anything. Then came the idea that they could stay signed up in an IDR and get some credit if the language covered that, but hardly anybody but me has ever used that in this district. And right. I didn't use the Buchanan,
and I've included
something else.
Right. I included the section of the published information in the written materials, so that's available if anyone wants to look at it. We're going to move on because we're running behind already. Sorry, Karen. We're going to talk a little bit about public service loan forgiveness.
Okay, so for people who work in either a government job, federal, state, local, or tribal, or any kind of a 501c3, this public service loan forgiveness program is wonderful. But okay, so there's 7 requirements you have to think about. Number 1 is only direct or direct consolidated loans count, not any of the other kinds, but you can probably do a consolidation to get those loans eligible. So you got to have the right kind of loan, but if they've got the wrong kind of loan, you can try to consolidate. Number 2, okay, you have to work for a qualified employer, the government or the nonprofit. It used to be that you could have, and this is still true, it doesn't have to be the same employer for the whole 10 years it takes to get forgiveness under this program. You can work 2 years here, take a gap, go do something else, go back and work 6 years to another place. It doesn't have to be consecutive. You can add them up. And the government looks at the employer's EIN number to figure out if they're a government entity or a nonprofit. And so going on to number 3, assuming you have the right kind of loan and the right kind of employer, you have to work 30 hours a week or whatever your employer deems equal full time. So you have to have the requirement. Now, they now are saying they used to have people put together multiple jobs, but now you have to work 30 hours a week for an employer or whatever the employer says. If they says 28 hours is full time, that's it. Number 4, okay, everything started in October of 2007. The 120-month count can start either October 2007 or anytime thereafter. There can be gaps, but you have to have 120 payment credits while at a qualifying employer. Number 5, you have to be current and not in default to get payment credit under PSLF. And as it has been, the bankruptcy payments in a bankruptcy don't count. But First, you can use the Fresh Start Get Out of Default program that's going on for a while now and will continue to go on to get people out of default. And you heard that hopefully payments under bankruptcy will count after next summer. Number 6. Okay, the payments must have been made while you were in a qualifying repayment plan. The reason this wonderful program was such a clusterfuck, excuse my French, is because the servicers did not explain these rules properly. And you had to not only have met the first 5 requirements, but all the payments of the 120 had to be in a qualifying income-based repayment plan. And that was the holdup where so many people got stuck. They didn't have they might have had 120 payments at the right employer, et cetera, but nobody told them they had to be in the right repayment plan. And there's also some other points here that are you can read yourself. Number 7. Okay, in order to do this, you have to move over and have Mohila be your servicer. If you submit the form, and there is an online form now to apply to both report your employment and your payments and to put in the final application for forgiveness, they've automated everything. There's an online PSLF help tool where you can actually fill out the paperwork and you can electronically sign it and your employer can sign it. And hopefully when you submit the last one, they'll agree. Now, the changes they made July 1st, the new rules are going to allow that certain late or multiple installments or lump payments are allowed. There used to be like timing rules and they would throw everybody off. No, they're basically opening the gates and allowing people to have a lot more payments count. And there's a special rule, and I don't know it as well as I should yet, but there are certain times when for certain times you can make up a payment later. And so that's a new feature that I'm still getting used to. Now, the biggest change is that people have been terrified to consolidate because they were afraid they would lose all the months they'd already built up. That's gone. They can consolidate again for whatever reasons they want to and continue on in the PSLF. Now, they will not lose their credits, but they'll get a weighted, going forward in the future, they'll get a weighted average. However, there was a limited waiver plan that ended last year, and there's the IDR recount you'll hear more about in a few minutes, where there are some more generous rules about what payments they will count. And the next one is the fact that when they've discovered how badly administered the PSLF program had been and what changes they needed to do, they decided that since the servicers have virtually no records and they apparently put people in deferments and forbearances all the time without ever telling them what they could do to qualify for PSLF, they decided that they would liberalize the rules and they would let periods of deferment and forbearance that were often done because the servicer told them to, not because it was the best idea. And so they're going to they're giving them credit. So not only payments, but certain terms in deferment and forbearance are going to be getting credit. So you can build up more of the needed 120. And there's also going to be credit under certain deferments and forbearances we're going to talk about more later. Anyway, it's not just a payment. Payment is not just paying money. Sorry. But I mean, in other words, so when you hear the word payment, it should be a broader concept now. Go ahead. There's one other weird little thing. For all those years that people were trying to do PSLF and nobody told them they had to be in one of the IBR payment plans, a couple of years ago, Congress passed a bill and said, okay, since the servicers are doing such a bad job, if the only problem for you in PSLF was that you had the wrong repayment type, you were not in one of the income-based, where there's a special program called TEPSLF, and it's still available. So if you come to find that the person meets every requirement except they never got put in the right payment plan, this program will solve that problem. Okay. And now, Mohila is the servicer, and you can have, as I said, you can, some of the other payment plans that would not normally have count will be available. And there's a formula which that they'll assess to look at your payment history and see if you qualify under TEPSLF.
This is one of those more complex issues. So if you want to talk more about it one-on-one, give one of us a call. We're happy to walk you through. We're going to move on. We're a little bit ahead. There's so much material to cover today. So I appreciate that we can get a little ahead because I think we'll get bogged down as we keep moving. But we keep referring to this IDR recount or income-driven recount. As Karen said, Department of Education recognized that the servicers were really not doing the borrowers any service by putting them into deferments and forbearances, the department's own policies that were very restrictive about what counted as income-based repayment payments have created this audit or this IDR recount process that will help to restore what should have been appropriate credit to many borrowers who either were misled by their servicer or who didn't understand the terms of the program. IDR plans, ICR, IBR, pay, repay, save, are supposed to forgive all the loan balances after you've been enrolled and made payments for 20 to 25 years. Because the audit found so many record-keeping problems, lack of servicer disclosures, et cetera, department says we're going to do a one-time true-up or a one-time fix. So initially, this program was supposed to be finished at the end of last year. I think based on Department of Education's budget constraints and the difficulty of examining 45 million borrowers' accounts, it's going to take considerably longer. But what they're doing is going back through each borrower's account to see what payments have been made and where they should have gotten credit for perhaps deferments or forbearances. The blanket they're going to give some blanket coverage, and we'll talk about those in a second. In order to be eligible for this IDR recount, you need to have a direct loan. So if your borrower does not have a direct loan, they must get one immediately. The deadline to consolidate to be eligible for this IDR recount is December 31st of 2023. That's like 3-4 months from now. Borrowers have to have their application filed by New Year's Eve on 2023.
I'm going to
so if you
one thing.
Go ahead.
This is critical. If you have a bankruptcy client coming to your office or you're in the process of filing a case, if you file a case and you have not looked at whether or not they should do a direct consolidation first, and they are then in a bankruptcy and then can't do it, and December 31st passes, they could lose a good opportunity to get their student loans forgiven. And so this is why knowing that FFEL loans should be consolidated, if you're confused, call one of us and we'll help you figure it out. But you've got to be careful because you could have a client with hundreds of thousands of dollars of federal student loans. You put them in a bankruptcy thinking, oh, we're going to do X, but you didn't check to see what kind of loans they have. Stretto is trying to convince people that, bankruptcy malpractice about student loans is a big thing. Well, I don't know that it's a big thing yet, but I do know that this is important.
I can tell you it may not be a thing, but I certainly don't want to be the test case in determining whether I've committed malpractice by not doing a consolidation. This is an easy thing to take a look at. You've got resources available. This program is a great start, but definitely need to be taking a look at what kind of student loans your borrowers have so that you make the right choice for a bankruptcy case.
And I'm not trying to make it sound scary or put an obligation on you. It's just that it is so, this is a one-time holy mackerel, holy grail kind of they're gonna fix the crap they've had for 20 years. And you'd hate to have somebody miss their chance.
I'll go so far as to say you should be a little nervous. I mean, I don't want to have to call my carrier about this, and I would be concerned. So I may be more cautious than Karen wants to make it, but I think you got to be careful. Basically, what the IDR recount is going to do is give borrowers credit, and this counts for both income-driven repayment forgiveness and PSLF forgiveness for any month in which the borrower was in repayment status. They don't care whether the borrower actually made a payment, whether the payment was partial, whether the payment was late. They don't care what kind of loan they had at the time or which repayment plan they were enrolled in. That's huge. I've got doctors who will never be in income-driven repayment, but they've been making payments for 120 months and their loans are so big, but they're public service folks. They're going to get forgiveness because we consolidated and put in their application. This is big. You're going to get credit for any month that the loan was in an eligible repayment, deferred, or forbearance status prior to the consolidation. We talked about this before. If the loan gets consolidated, you're still going to get credit for where it was before the consolidation. The months that any borrower spent that were at least 12 consecutive months of forbearance. So if you were in forbearance for a year and a day, you're going to get credit for all 12 of those months. They're going to get credit for any month that they spent if they were more than 36 cumulative months in forbearance. A lot of times what you see in the transcript is they were in forbearance for 11 months, they were in forbearance for 6 months, they were in forbearance for 11 months. If those add up to a total of 36, they'll get credit for all of it. Any month that the borrower spent in deferment prior to 2013, the only exception is in-school deferment. So if they were in deferment because they were still in school, that doesn't count, but everything else does. The only thing that doesn't count are months that were in default or months in a bankruptcy forbearance. So those don't count as forbearance months. But this can add up to a huge number of payments for a lot of folks. I've got a question. If loans are already federal direct loans, they don't need to be consolidated, correct? That's absolutely correct. You just have to have a direct loan. Beginning in November, borrowers who have, this was supposed to be November of last year, we're just starting, we just saw it in early August, end of July, the first borrowers getting their forgiveness. Karen's got some, I think, Karen, did you say you got 1 million?
Well,
give me the number. What have you had forgiven so far?
It looks like at least 1 million from the July 14th emails. These
So
are
first round, $1 million for your clients were forgiven.
And that's only the ones that have thought to tell me. I've had people
Got it.
email me late going, is this real?
Right. So this is happening now, finally. So borrowers who had 20 years, 240 months of payments, or 25 years of payments, or borrowers who did public service loan forgiveness and had 120 payments, all are starting to get forgiveness. And the department is really trying to prioritize those accounts where they think there are enough payments for people to get forgiveness now. So if you've got a client who's only got 4 or 8 or 18 years and they're not public service loan forgiveness eligible, it's going to take a while. I have several clients who call every other week to find out why they haven't received their updated IDR recount number. It's going to take a while. So if they're not close, it's gonna be a while out, but we're going to see bi-monthly reviews coming out. The department's going to automatically apply those accounts. For people who have exceeded, there are also refunds that are going to be paid. So if the borrower had a direct loan or another federally funded loan, and correct me if I'm wrong on this, Karen, they do get refunds of payments that they made in excess of what was required.
Yep.
So that could be another biggie.
As long as it's department. One thing, there was a lawsuit attempt to stop this but the lawsuit was dismissed. And today, one of my client who's with a servicer called A Advantage, she got her first forgiveness letter. So the department, even though there was an appeal filed, I don't think that's going to succeed. The department, as of today, is sending out your forgiven emails. I mean the servicers, excuse me.
Yeah, pretty amazing. Borrowers who have commercially managed FFEL, Perkins, HEAL loans, which are health education assistance loans, other non-direct loans, must apply for a direct consolidation loan by December 31st to get the full benefits of this one-time adjustment. So again, I'm probably going overboard, but if you walk away from this program with one thought in your head is check for FFELs and do consolidations. Just don't include Parent Plus loans in those consolidations. If you've made qualifying payments that exceed that forgiveness threshold, as long as you don't have commercially backed FFELs, you get a refund of overpayment. There are brand new programs rolling out for those who have joint consolidation loans. There's the Joint Consolidation Loan Separation Act that passed in, was that 2019, Karen? 2020?
No, it just passed last fall.
Oh, 2022. Okay.
Yeah, Biden signed it in October of 2022.
Okay. How many borrowers did you say? Like there's 30,000 borrowers with these joint consolidations?
There's only
300,000
of loans. Married people could put their loans together, but there was no way to separate them. So if you got stuck with a divorce or domestic support, or you couldn't ever split your loans again. And in October, he signed a bill, but the department is not going to be able to separate them until next year. But you can tell the department, wait, save my forgiveness rights and give them back to me when you get your act together on separating these loans. So there is a way for those people to still take advantage of these current programs.
Right.
If they register.
In addition to that, we also have programs that allow borrowers who are in default to still benefit from this IDR account adjustment, as long as they use the Fresh Start initiative, which we'll talk about next, before September of 2024. So if you know of a borrower who's in default, or somebody says to you, yeah, I just haven't paid in forever, this is the premium time to get out of default, because they'll get credit for all of their past payments, their deferments, forbearances. Oftentimes borrowers go into deferment or forbearance multiple times before they go into default. And so if they can get themselves out of default easily with the Fresh Start initiative, and then before September 2024, get that loan out of default, and they get credit for IDR forgiveness. How do you tell how many credits or how many months of credit you might get, or a borrower might get? Karen and I have a colleague, Stanley Tate. He is a primarily student loan lawyer, but he also does bankruptcy work. And he has created this awesome tool. You use your text report, the borrower's text report, upload it to his tool. It's free. You just have to provide the email address, and it will provide an estimate of how many months of forgiveness there are. And what I love about the estimator is that it shows exactly how many, based on the report, months they have in forgiveness, in forbearance, in repayment, and in deferment. So this is what it kind of spits out. You'll see here that this particular client has an FFEL consolidated loan. And so we want to be really careful when we see that. Obviously, let's get them out of that loan. They have 193 months in repayment, 15 months in forbearance, and 121 months in deferment. This loan also originated in 1995, so not all of these payments will likely qualify, because we're only looking back on this IDR forgiveness to October of 2007. But they still have quite a bit of credit. This is a prime candidate. This is actually a client of mine that I was ready to put into a Chapter 13, and one of just said, we got to check your loans first. We're holding the 13 to get the consolidation completed. So that gives you an idea of what that looks like. I think it's a super handy tool. Looking through the text file to see how many months we think they might get is tedious and terrible. So using that tool that Stanley has put out is, I think, such a really huge advantage for all of us. The information can be used then to determine what they need to do next. We're going to move on to the fresh start and consolidation process. So we've been touting the need to get these loans out of default. We've talked a little bit about what happens to defaulted loans. If you haven't made a payment in at least 270 days, you're likely in default. Default results in acceleration, which is the demand for an immediate repayment of the entire outstanding balance on the loan. Since March of 2020, if your federal student loans, direct or any FFEL, regardless of who owned them, were in default or went into default, the department stopped collection activity. Collection activity can include anything from phone calls to wage garnishments, tax refund offsets, and Social Security garnishment. To help get these borrowers out of default, the department announced special rules called Fresh Start. And it really allows anyone in default to get out on special terms within the next year. Borrowers have, like I said, until September of 2024 to return their loans to good standing. The benefits to doing that are huge. The borrower gets renewed access to the federal student aid program. Say you've got a borrower who's in default and they want to go back to school. They can't do that and get federal student aid. They have to use private loans if they want to go back to school if they're in default. Fresh Start lets them get it right away. Obviously, it stops collection activity. I think another important factor here is that they remove the federal CAVERS reporting. CAVERS is the Credit Alert Verification Reporting System. It makes them eligible for other federal loans, SBA loans, mortgage loans, FHA loans. So if you've got a borrower who's in default and they can't qualify for a mortgage, Fresh Start will help them by getting that reporting off. It restores the borrower's eligibility for future rehabilitation. So we didn't really talk much about ways you got out of default in the past, but you either had to consolidate out of default or, more commonly, do what's called rehabilitation. And rehabilitation required the debtor make 9 out of 10 regular monthly payments on the student loan, kind of a trial payment period, if you will, before they received full reinstatement of the loan, which meant renewed access to federal student aid, stopping collection activity, etc. You could only rehabilitate your loans once. So if you went into default and had already rehabilitated your loans and went into default again, there wasn't an option to get out. Fresh Start gives you another shot at rehabilitation down the road. It also provides access to the IDR recount as long as you do it before September 2024. Also gives borrowers access to various forgiveness programs like public service loan forgiveness, like IDR, like borrower defense to repayment, and other federal student loan benefits.
And it only takes one phone call. I mean,
right.
The borrower calls up the special office and they say, I want to enroll in Fresh Start.
That's it. Here's the information. They can go online to myeddebt.ed.gov. You have to have a login to be able to get in there. You can call the department at this 800 number. They recommend you have their most recent tax return available because they're going to enroll them in an IDR plan immediately. That call is supposed to take about 10 minutes. They can also send a letter, P.O. Box 5609, Greenville, Texas. Just put their name, social security number, date of birth, and a statement that they want to use Fresh Start to bring their loans back to good standing. Easy, easy, easy process. I'm going to go back one. There are certain loans that are not eligible for Fresh Start. So I want to talk about what those are because that's important. Defaulted school-held Perkins loans, not eligible. Defaulted HEAL loans, those are usually medical professionals, not eligible. Student loans that are already with the United States Department of Justice, meaning you've been in default so long and ignored it that you're being prosecuted, Direct loans and commercially held FFEL loans that defaulted after December 31st of 2022, so during the pause. No direct loans would have defaulted after the pause because they were already on pause. So it's really just commercially held FFEL loans that went into default after December of last year. Everybody else is eligible. Defaulted FFEL loans, ed held and not ed held, as long as they didn't go into default after the December of 22. Defaulted ed held Perkins loans, Stafford loans are eligible. All of those things are eligible. So it's really a big deal to get folks into this fresh start if they're already in default. I want to step back. For maximum benefit, we've talked a lot about consolidate, consolidate, consolidate. But for maximum benefit, you want the debtor to use Fresh Start first and then consolidate the loans. So we've talked about, hey, if you've got FFEL loans, what if they've got FFEL loans that are in default? We need to get them out of default first and then consolidate them. It should just make that process easier.
And they're saying that Fresh Start will take about 45 days right now from a call the other day. Well, that's 45 days plus a consolidation could take another 45 days. If you've got to put a 90-day window on the front of your bankruptcy consideration, this is important because of that December 31st deadline for doing the IDR audit.
Karen, if a consolidation application is filed, can you file a bankruptcy even if it's not granted?
Well, I don't know the exact answer to that. I would say you certainly should try. You certainly should do it. The problem is they're kind of set up to put you on a bankruptcy forbearance the minute they hear about it. I'll have to ask the ombudsman that, and I'll tell everybody an answer when I get it.
Great. So we've been harping on consolidation, consolidation, consolidation. Basically, it's pretty straightforward. This is a process where a borrower is going to pay off one or more of their outstanding loans with a new loan. Keep in mind that consolidation of federal student loans is not credit-based. I have clients who are concerned that they won't be approved because their credit's bad. These are not credit-based loans. The consolidation will allow borrowers to enroll in income-driven repayment plans in any of them because you're only going to be able to consolidate into a direct loan at this point. Again, we've stressed how many benefits there are. Let's talk about what the process is. I included in the materials a copy of the consolidation application and promissory note. So you can take a look at that. You don't have to do the paper application. Borrowers can do this directly at studentaid.gov. Just go to the top, repayment, and then consolidation. The application has 5 parts. You've got to provide borrower information, including name, social security number, address. You also have to provide 2 references. The references have to be someone who does not live at the same address as the borrower, but they're not used for anything other than collection purposes. So these individuals aren't going to be financially obligated on the loan. They're not going to do a credit check on any of these people. They're basically people that the department will call if they can't find the borrower. And the main reason the department's going to be looking for the borrower is they've gone into default on the consolidation loan. You have to list the loans that you want consolidated. You can find all of the loans listed on the text file. If the borrower does the consolidation application on the department's website, it will auto-populate those loans. You can pick which ones you want. Also need to select a servicer. Back in the day when there were really bad servicers that we didn't want our clients to use, this was one of the main advantages to consolidation out of default was you got to pick your servicer. I think all of the servicers now are decent. So clients ask me which one I like. I don't have a preference. Do you have a preference, Karen?
Well, they have to do MOHELA if they ever are going to do public service loan forgiveness. So you tell them that. And then
Right.
I don't see OSLA very often, and then Ed Financial is never done for me. So I usually say, tell them if you haven't had a bad experience with Nelnet, you might want, or if you have loans already there. Let me tell you one more thing. if you go online to studentaid.gov and you go to the Consolidate Your Loans page, while your client is at their computer, if they're not with you, they can go through and do the consolidation application. And it helps if you're on the phone with them or in person. There is a demo. So if you go to Consolidate Your Loans, they have a demo. And so I walk through the demo telling my clients what to do and where they are, while the clients fill out the actual form. And most of them like having somebody there to help them. You can do it in half an hour and you make them so happy and you make sure they don't make mistakes, etc. So, you know, you can also do a joint Zoom or you can have them in the office, but with my disabilities, it's been great for me to be able to be on my phone and have them. And really, half an hour, and they get the confirmation at the end, and then you tell them, just send me everything you get about this to make sure things are good. And
I think that's an important note, because even if you are their attorney, the Department of Education will not communicate with you, only with the borrower. So it's important that you remind clients and tickle your own system if you're going to do any of this work to follow up with them when you are expecting their consolidation letters to come in.
One more thing to tell them. When they do the consolidation, they not only have to pick a loan servicer, but they pick a repayment plan. Because oftentimes, getting better now, they would pick an IDR repayment plan, and somehow the servicer would tell them, yes, your consolidation is done, and here's your payment plan, and it would be wrong. So I always tell my clients, when you get the information about your consolidation, tell me so we can proof it, because you have 10 days before it it's finished. And you have 10 days to say you don't want to do it for some reason. But the other thing is, when they get their repayment plan, it is sometimes wrong. And it's important to make sure that they got the right one, because oftentimes they'll get something about the standard repayment, and that's usually the most expensive. And then they panic and they're like all upset. And they're like, why did you tell me to do this? No, that's not your IDR plan. So that's the only problem I've ever had with consolidations, is the new servicer somehow tells them of the wrong plan. So I warn people about that problem so they don't panic and they call me and say, oh, you were right, this is wrong, now what do I do? You just call the servicer and you point out to them that they sent you the wrong one.
True. If you're doing this in paper format, you need to submit a paper IDR request in addition to the application for consolidation. But if you do it online, it'll do it all together at once, which is one of the advantages. Finalizing consolidation. Once the application's submitted, the consolidation servicer will complete processing it, pay off the old loans. They must complete it within 180 days. Often takes way less time than 180 days. As of July, I was running about 30 days. Have you had them run about the same?
Yeah,
Karen?
that's about it.
Yeah. Direct loan consolidation program summary sheets go to the borrower showing the loans that are eligible for consolidation. You confirms the payoff and the repayment plan selected. This is what Karen was talking about. Borrower has 10 days to decline consolidation or make corrections, and 180 days to add loans. So say they missed a loan or somehow didn't get them all consolidated, you can add loans for up to 180 days. There are some strategies that student loan lawyers use sometimes to do multiple consolidations. That can be difficult to do online if this 180 days is still pending. You may have to submit a second application by mail. And then the next communication for the borrower is usually the billing statement that shows the payments that are due. Super easy process. It goes very smoothly for most borrowers. The major issue really is just that, did they get it into the right repayment program? There are a couple risks of consolidation. I think the one that we've really talked about a lot is this Parent Plus issue. Parent Plus loans should not be included in a consolidation loan in most cases because it makes borrowers ineligible for the main IDR programs. they're only eligible for ICR, which is that highest percentage of discretionary income. Another factor, and this comes up much less often, Perkins loans that are consolidated into direct loans will lose their Perkins cancellation rights. So that's something to be aware of if your borrower has a lot of Perkins issues or are looking at getting that cancellation. One of the strategies that we have heard are successful, again, exclude Parent Plus loans from the consolidation, pay them separately so that you can get IDR forgiveness on everything else, pay the Parent Plus loans continuing. Some borrowers have reported success in doing basically a double consolidation. So first you consolidate all the loans that you have, then add another non-Parent Plus loans. So you've got Parent Plus loans, then they're in a consolidation loan, then you do a second consolidation loan. And then those Parent Plus loans kind of lose their characteristic. I think this is tricky. Right now, the department has confirmed that they can't see that. On a call we had with the ombudsman, she said, yeah, it's a known issue. We can't see that. I wouldn't guarantee that will continue forever. So I think you've got to really get some CYA around letting borrowers do double consolidations to avoid that Parent Plus issue.
Because eventually the department could find out about that double consolidation and go, oh, you know what? That's breaking the rules. You got to pay all your loans now under ICR. And,
Right.
people are very unhappy about that.
That is not a good situation. We talked a little bit about these others, why consolidation is critical. Here's an example. A client came to me for a Chapter 13. She's a longtime teacher with a ton of excess home equity. So there's no urgent reason to file her other than to do this, avoid turning over her home. I see the student loans, ask for the text file. I see that she's got that FFEL consolidation loan and a direct Stafford loan, which direct is fine. It's the FFEL that's not. We do an evaluation. We see that she now has sufficient repayment to gain forgiveness under PSLF. If I failed to do that prior to filing the bankruptcy, she would have missed out and would not have gotten her forgiveness. Big deal. We're going to talk next about non-bankruptcy discharge.
Yes. So the first one we're going to talk about is total and permanent disability, which surprisingly enough is something I care a lot about. As I sit here in my new power wheelchair, I do these things all the time. If you have somebody that could qualify and you don't want to do this part of the case, call. Tara will probably be sad about this, but I do total and permanent disability work pro bono because I'm so passionate about it. Anyway, all the loans are eligible, and if they're not, you can consolidate them. Parent Plus loans, it's the parent disability. This is a program where you tell the Department of Education, you have disability requirements, department. I'm sending you the paperwork or the information to see if I qualify, and then within 60 days you get an answer. And the thing that's tricky is to understand the definition of disability, because it's not Social Security's disability definition. It's nobody else's definition. They're eligible if a licensed medical provider believes they are, quote, unable to engage in any substantial gainful activity by reason of any medically determinable physical or mental impairment that can be expected to result in death, can be expected to last for a continuous period of 60 months, or has lasted for a continuous period of 60 months. Well, that's a lot to get your head around, exactly. So what is that? Well, okay. Number one, there are 3 ways to get a total and permanent disability discharge. If the Secretary of Veterans Affairs says you have 100% disability rating with the VA, you get it automatically and you get it quickly, and they don't even do any further review. And the VA is supposed to be telling the Department of Education about all these, but they do miss some, so they could show up. Now, there's a second method, and that's for people who are getting Social Security disability. And if you're already getting it, all right, and your medical review time is 3 years or more. It used to be 5, but as of July, if it's 3 years or more, the Social Security Administration is supposed to tell the Department of Education, and you're supposed to be able to get a TPD discharge. However, they miss some people. So you could have someone show up who meets these requirements, or you have somebody who had a 3-year time frame for medical review, but had a 5-year, and now it's only 3, so they could now qualify. I don't see very many of these type 2 because the system is now set up for the Department of Education to be told about these people. The next slide, I think.
Sorry.
That's okay. This is the one that I see a lot. And most people don't even understand they could qualify because it doesn't occur to them that their situation matches disability. But anyway, as of July 1st, any doctor, MD, or DO, any physician's assistant or nurse practitioner or independent certified psychologist, any of those licensed medical providers can fill out a 1-page form, page 3 of the TPD application. And if you submit that where the doctor has filled out all of the boxes and has said that yes, they believe you are totally disabled under that definition of the 3 bullet points there, then almost always the department will grant a discharge. Now, I have a special letter, and I'll put it on the listserv tomorrow, that I send to doctors. I don't find doctors for people. I don't get into any of that nonsense, but I give people a letter and I say, give me your doctor's address and we'll send a letter to your doctor. And it explains what they need to do because most of them have done Social Security disability stuff and they hate it and they don't like it and they've never seen this form before. So I give them a letter and I say, go find your medical provider that's most sympathetic to your problem and see if they will sign the form. And almost always the doctors will sign. And this is a lot of people have chronic health problems. They don't think of themselves as disabled. So if you're talking to bankruptcy clients and they're talking in terms of lots of chronic health stuff, they may not think of themselves as disabled, but they may be eligible for this program. Can we go on to the next one? So, substantial gainful activity. It all is in the doctor's interpretation of page 3 of the form. And it's a simple thing where they go through. I have people who, the department does not say you can't work. It's not that you can't work. So I have people who do a little bit of work. They can still get a TPD disability discharge if the doctor feels that they have limitations. So if you have any case you have a question about on this kind of thing, just call me. Nelnet is the approved servicer to do this. There used to be, and this is what stopped a lot of people, there used to be a 3-year income monitoring period, but it's not happening anymore. They don't check your income. They don't look. The only thing that happens is they monitor you for 3 years to make sure you don't take out any other loans, and you don't have any change in your status with the Social Security. But now it's just the doctor signs the form and you are probably good to go within less than 30 to 60 days. Let's see. Now, I'm gonna, let's see, borrower defense to repayment. Okay. This is a process the department has had for many years to cancel loans, and it's gotten a lot of publicity in the last couple of years because so many of the schools started to close. When Corinthian collapsed in 2015, that's when they started to have a process. In other words, for many years on the books, it said there could be this kind of a discharge, but hardly anybody did even try. But starting in 2015, after Corinthian had stopped, the Obama administration put some rules into place, and we can go ahead. Okay, so the rules changed as the administrations changed. So there were different schemes and different rules. Loans prior to 2017, loans between 2017 and 2020, the Betsy DeVos era for Secretary of Education, and loans issued after July 2020. Now, as of July 1st, there were new regulations for borrower defense that were supposed to take effect, but a lawsuit, an injunction has been filed, and the hearing for that is November 6th. So there are not going to be any decisions made, although you can still put in an application. Only direct and direct consolidation loans are eligible. So again, you can go back to all of our previous comments about why people should consolidate. There is a great deal of talk, and let me just take a minute or so. There is a lawsuit that used to be called Sweet versus DeVos, but now it's Sweet versus Cardona. When the BDTR big push happened, starting after 2015, people put in applications, but the department did virtually nothing with those applications, and the backlog got to be over 300,000 applications that were just sitting there. And so Teresa Sweet and her other folks working with the Project on Predatory Student Lending sued Betsy DeVos to say, I can't just sit on these things. And she didn't do anything even after the lawsuit until finally the judge told her to start reporting. Well, she set up a sham processing to review the applications. And so she got brought into court again about that because they were doing, New York Times had a great article about they had like an assembly line thing where they would like look at an application and go, nope, 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 nope. Anyway, so there was a settlement for this lawsuit that fell apart. Last June, the department and Sweet's lawyers and Sweet reached a settlement, and it's a nice, very generous settlement. We don't have time to talk about it today, but that little website there, ppsl.org, will tell you everything you want to know about it, or you can call me. It covers 150 schools, and it includes schools that weren't on the original list, and you can still apply for BDTR outside the lawsuit. Okay.
Thanks, Karen. Sorry we had to rush that, but I really want to get to what most of you are probably here for, which is bankruptcy discharge. So that's where we're going to head next. Back in November of 2022, the Department of Justice announced a new program, a new guideline to handle student loans in bankruptcy and hardship discharges. So the Bankruptcy Forbearance Impact Department of Education and their servicers' position is that they would stop communications with debtors as soon as they filed bankruptcy. So they'd put them into bankruptcy forbearance. Now, beginning in July, they're not going to just shut them down. They're going to continue to get IDR forgiveness if they're in Chapter 13 plans. That's great. It still doesn't discharge the debtor of an obligation to pay student loans. So we've talked a little bit about some of these other issues, and we're going to go straight in to the discharge categories. Under 523A8A1 and A8B, student loans are accepted from bankruptcy discharge absent a showing of undue hardship, which requires an adversary proceeding to be filed in the bankruptcy court. Unfortunately, undue hardship is not defined in the code, and so really that definition comes from case law development. The standard for bankruptcy discharge that's followed here in Colorado is the Brunner case standard. Under Brunner, the court is going to look at three factors. Whether the debtor can maintain, based on their current income and expenses, a minimal standard of living for themselves and their dependents if they're forced to repay student loans. Two, whether there's additional circumstances that indicate the hardship will persist for a significant portion of the repayment period. And three, whether the debtor has made good faith efforts to repay the loans. These cases were very difficult because the Department of Education, through the Department of Justice, was vigorous in their defense of undue hardship cases. It was, critical to consider whether, one, the borrower could withstand that kind of scrutiny. We don't want, borrowers who can't handle that litigation. And many bankruptcy attorneys advised that undue hardship was really not possible. And so we started looking at other things like TPD, borrower defense to repayment, public service loan forgiveness, and zero IDR repayment. Again, last November, Department of Justice released new guidelines regarding student loan bankruptcy litigation. The guidelines, as well as all the materials that were released by Department of Justice, are in the materials that we provided. The guidance is provided to assistant U.S. attorneys. It's supposed to be a framework for them to recommend discharge of student loans. Department of Ed and Department of Justice are kind of flipping their approach to these, or they're supposed to be, so that borrowers who are attempting to discharge student loans under this hardship standard are not going to be met with unnecessarily burdensome or time-consuming investigations. Not long depositions, not extensive research and questioning of every time they purchased a McDonald's dinner. Really, the process was intended to help identify borrowers of, who could meet that criteria and get a discharge. I think it's really important to stress that if you're looking at a borrower hardship application, the bankruptcy case has to have been open with the bankruptcy court as of November 17th, 2022, or later. You can't go back and reopen old cases to take advantage of the new guidance. That will be held, those cases will be handled under the old undue hardship criteria. You will not have eligibility for this. So if you have a borrower who filed a bankruptcy a while ago, it may be appropriate to talk about a new bankruptcy case filing if their case was not open last November. The new DOJ guidance really tracks the Brunner test because it focuses on three factors. One, what is the borrower's present financial circumstance? Two, what are their future financial circumstances likely to be? And three, have they made good faith efforts to repay? It's really clocks right along with what that Brunner test looks like. The new guidance uses a 15-page attestation form, and we're currently on a version 3, although I can only find version 2. And Karen, I don't think you found version 3 either. It's supposedly out there, but nobody has seen it.
We'll post it on the list as soon as we find it.
Yeah. So the idea is that counsel for the debtor borrower will use that attestation form to provide the relevant information that an assistant U.S. attorney might need to assess the factors for discharge. The attestation form utilizes some of the IRS national and local collection financial standards that we use in our means test analysis to evaluate the debtor's expenses and compare those to their gross household income. You can also add some projected reasonable expenses that may not fall into those IRS national and local collection financial standards. The undue hardship calculation generally allows for deduction of up to the IRS standard, but will cap the allowed deduction at the debtor's actual expense. So to just kind of give you an example, when we do the means test, if the borrower or the debtor has a household of one in Adams County, they're going to get $1,100 a month for rent. If the borrower actually pays $900 a month in rent, under the means test, we get to claim the full $1,100. Under the attestation, you only get what they actually spend, the $900. So there are some differences between the means test calculation and this attestation calculation. The form does allow the debtor to claim monthly expenses that are not covered in parts of it as excess expenses. And it's always a good idea to just provide an explanation as to why you're claiming those. For present financial circumstances, the debtor's gross income, here's another deviation from the means test, does include monthly Social Security and unemployment. Those are usually accepted from the means test, but they should be included in the attestation. If expenses are greater than the income, then you've satisfied the present financial circumstances portion of this criteria. If the debtor is able to show the ability that they can pay a significant portion of the loan, it doesn't mean they're not eligible for this program. It just means that they will likely get a partial discharge. There's a 10th Circuit case that we've listed here in which the court allowed a partial discharge even if undue hardship is found. So there is kind of a a gray area here of exactly what they'll get.
And remember, at this point, you're still working with the assistant U.S. attorney. You're not at the judge. The whole idea of this program is to get a settlement agreement to present to the judge, not to have the judge treat this like a trial or a normal trial. So I think that's important to remember. It's
Right, and I think the whole goal is to just make it less litigious.
yeah.
Come to some agreements. There's still the possibility that you could go down that road if you can't reach an agreement, but the goal of this program is to make this more achievable for more debtor borrowers. For the second prong, the future financial circumstances, there's some presumptions. So if a debtor can attest to circumstances that justify one or more of the presumptions, again, if there's more than one, certainly check. This is a check box. Check all the boxes that you can. So we're looking at these presumptions include the borrower debtor is already over 65 years old. They've already been in repayment for 10 years. A good way to check that is to use, Stanley Tate's calculator. It'll give you a printout of exactly how many months they've been in repayment, forbearance, and deferment. Did the borrower complete their education or get a degree for the loans that were taken? Maybe if they didn't, it's a presumption of future financial circumstances. Do they have a permanent disability or chronic injury that limits or prevents them working or that impacts their income potential? I wouldn't file an undue hardship case if they have a permanent disability or chronic injury that limits or prevents substantial gainful employment. Follow the TPD rules instead. It's so much faster and easier. But if you've got a borrower that otherwise qualifies here, it might make sense. If a borrower's been unemployed for 5 of the last 10 years, a good way to get that information is to check their Social Security record. You can order those through the Social Security Administration to show their periods of unemployment. Or has the loan been in payment status other than in school for at least 10 years? Maybe they haven't been paying, but they've been in deferment or forbearance. These all give rise to a rebuttable presumption of a future inability to pay. They're certainly not the sole factors that the Department of Justice is going to consider. So if you have additional factors, include them. If you've got a child that has autism and it prevents you from working because you've got to take care of them, that should be listed. In this future financial circumstances, the debtor's assets that are not considered if they're difficult to liquidate or they're essential to the debtor. So the fact that the debtor has some equity in their home isn't going to count. If the debtor owns something that's difficult to liquidate, that's not necessarily going to count against them. The last piece, the last prong is this good faith effort. Again, this is kind of a checklist as well. The assessment of good faith is going to be assumed if the debtor or borrower has taken at least one of these steps. Have they made a payment on the loan? I had a potential client call today and say, I've got these Parent Plus loans. My daughter took out, which, you can't take out a loan for someone else, but the kid apparently took out the Parent Plus loans. And she just graduated a month ago. Well, you gotta at least make a payment, make some payments. Have you applied for a deferment or a forbearance? Did you apply for an income-driven repayment program? Have they applied for a federal consolidation loan? Have they responded to outreach from the servicer or collector? Did they pick up the phone when the servicer or collector called? These are not hard to meet. Have they engaged meaningfully with the department or their loan servicer regarding payment? Forbearance, deferment, loan consolidation. Have they engaged meaningfully with a third party, an attorney like you, that they believe might be able to assist them in managing their student loan debt? If they've had an appointment with you and you've talked about student loans, you can check this box. I think there's some positive indicators that this guidance will be successful. There have not been many cases filed. I had the list here in my hand just a few minutes ago, and I can't find it. I think there have been 5 cases in Colorado. 3 are pro se. No, 5 cases in Colorado. 2 are pro se. 1 was filed by Robert Robertson Cohen's office, and 2 were filed by Jesse Sweeney's office. All 5 are currently on kind of hold while the AUSA makes their considerations. In talking with Jesse Sweeney's office, they said that our AUSA seems to be asking for a lot of documents and information that we're not really thinking that we were going to have to provide, but they're providing documents and information at this point. How many nationwide, Karen?
406, and I think something like 40 discharges granted. I think you have to understand, for example, you'd say to yourself, well, if there's 5 cases in Colorado, how come neither of the 2 of you have filed any yet? Well, I got a stack of them, but I haven't been able to get off the phone for about 2 months, and this takes a little bit of work. And we were all tiptoeing. We were told basically by every advocacy group that we know of to start tiptoeing into these cases and don't file bad ones to start with. So I have a bunch there. I'm going to break a log jam pretty soon and start filing some. But it's just been a little bit of a slow start nationally because everyone's trying not to make bad law and not have problems and learn how to do this. The one thing I think I'd like to stress before I shut up is that don't forget your complaint. Your complaint is a place to make the case with the attestation. You know, you've got two things you're essentially supposed to give to the ASUA to make your case.
Right. So, and we'll get to how, practical steps of how to do this. Couple of things I just want to point out. One of the things you have to do in the attestation is calculate student loan payments, but the way that they're calculated is using the standard monthly repayment. The Department of Justice recognizes that for a long time, the argument against student loan hardship discharge was, well, there's IDR. You could just do a $0 IDR payment for the rest of your life and you'll get rid of the student loans. That's kind of being poo-pooed in this guidance. So the calculation of what their future student loan payment will be is not the income-based payment. It's the standard payment. And that means paid off in 10 years. That's huge. Those are big payments for a lot of clients. The idea is really, again, to reduce that protracted scorched earth litigation. We are hearing mixed reviews across the country of how the AUSAs are handling these cases. And the goal really is that they shouldn't be imposing their own values on a debtor's life choices. If you happen to file these, please communicate with us. We all want to hear what's happening. And I think the other piece is if you're having trouble with the AUSA, there are certainly advocacy channels we can go through. We have an incredibly responsive executive U.S. trustee in Tara Twomey. And so really no good faith if the debtor is contriving a hardship or trying to abuse the system. Don't file those cases. Come on. This is just common sense. It's practical procedure. You're going to file an adversary proceeding by filing a complaint with the court. A summons will be issued just like in any other adversary proceeding. You want to make sure you're serving the Department of Justice, U.S. Attorney General, U.S. Attorney for Colorado, and the servicers. Follow Rule 7004. In the complaint, make sure you're alleging jurisdiction and venue. Tell their story. This is your chance to set this case up. Talk about why this is a hardship for them. One of the cases I have that's getting ready to be filed, I have a borrower who's a teacher. She is working in a private school, so it's not public service loan forgiveness eligible. She works with disabled students. She really wants to have her own family, but because of her student loans, she's scared to death to have her own family. I'm telling that story for her because I think it's really important that we get those details out. The Department of Ed is supposed to be providing the assistant U.S. attorney and the debtor with the account history and loan details, something we're calling the litigation report. We should be comparing that with the text file and the debtor's recollections on their repayment and their communications with the department. If you're able to reach a settlement with the AUSA, the parties are going to file a stipulation and request the bankruptcy court enter judgment. Those stipulations can range from partial discharge to complete discharge, but certainly are better than full-scale litigation. If you don't get a settlement from the AUSA, you're still going to move forward or have the option to move forward on a regular hardship discharge case. So when you're drafting your complaint, it really should be with an eye towards receiving, moving into full litigation if that becomes necessary. There are some great resources out there for hardship discharge cases. There are lots of organizations, NACBA, NACTT, ABI, NCLC, NASL, which is the new National Association of Student Loan Lawyers, and Student Borrower Protection Center. All have great resources. National Consumer Law Center has their Student Loan Borrower Assistance Project. You can do a free training with NCLC if you agree to take pro bono cases. They've got good student loan hardship discharge materials, and we've got the link in there as well. Any questions about this process? We ran through it so fast, and I think as Karen and I each get hardship discharge cases filed under this new guidance, we're happy to help with attestation, fill out, and share those complaints. They're not difficult to do. They just take some time. You've got to really kind of be willing to tell the story. The question we get all the time, or I get all the time, is how do you charge for this? I think that's still up in the air. The nice thing is that you can start charging for this as soon as the bankruptcy case is filed because it's post-petition work. I've heard from various lawyers that there's a couple different ways they're going about it. They're charging a flat fee to move through the attestation process. One attorney in the country that I've heard from is actually filing these on a kind of contingency basis, that the borrower starts making a regular monthly payment to the lawyer. It goes into the trust account. If the hardship discharge is achieved, that money that's in the trust account will pay towards that contingency. And the contingency is like a percentage of what they get forgiven. So if you've got $100,000 in student loans and I charge you a 10% contingency, I would get paid $10,000 on that. So that's one strategy that one lawyer in the country is using. I think it's really up in the air. It's a case by case basis for me. What can they afford and what makes sense? Certainly parents and other family can help, but for some borrowers, that's just not even an option. And so I'm not going to preclude people just because they don't have funds.
Well, and the other thing is I guess, I don't know, I've done 10 or 12 adversaries before this. I've almost always done them after their bankruptcy is finished. So I've never filed a fee disclosure in any of my bankruptcy adversaries, and I don't know of anybody who ever has. So really the question comes down to, figuring out the person's finances to figure out, how and when can they pay you? How much will this cost? The thing to make them understand is this is not part of a standard bankruptcy, and it's going to be a
Right.
very case by case. But remember, you don't file in this district, you do not file to reopen the case. You don't, even if it's years after, you just file the complaint, and there's no reopening fee either. There's no fee for filing the adversary complaint. You start with the adversary complaint and move on. Now, during a chapter 13, I guess I haven't done that yet, so I'd have to think about the whole process of how that would go if you filed one during the 13.
Yep. And honestly, if I'm filing during the 13, I might wait until the 13 is close to discharge before I consider one of these cases, especially given the new guidance that you're going to get IDR credit during the 13, because then we can make a decision when they're finished what we want to do. One question that popped up in the Q&A, how do you charge fees for this work prior to bankruptcy? I can speak to what I do. I charge flat fees. I charge a flat fee to evaluate, give debtors or borrowers an idea of where they are. So that's me reviewing their text file to tell them this is where you're at as far as future forgiveness. How far along are you? What is your current income and how is that going to translate into a payment plan? and kind of what options they have, just to give them a lay of the land. Then I charge flat fees for consolidation, for IDR enrollment if they need ongoing assistance with that. Most borrowers can do that on their own, but if they need help, we'll do it. Rehabilitation, if that's not available. Fresh start, they don't need our help, they just have to call. So I'm certainly happy to handhold that, but really for me, it's evaluation and then assistance with consolidation at this point. And as things move, they can be something different. Karen, do you want to speak to that?
Yeah, I have a student loan retainer, and usually I give them a consultation quote, and then it's very piecemeal. Each piece you do, here's my price, here's what I will charge you. Do you want to do this? You can take payment plans if they're not in a bankruptcy. So, or if they're not about to file a bankruptcy. So, we have payment plans set up for them to pay. The other thing is, once you have these clients, they're yours for a whole lot longer than just a bankruptcy. I mean, I have people that I have had as clients since 2006, and every year they come back to check in and see what they need to do, because they're so confused even after working with me, because everything's changing. And for me in my office right now, I'm having flashbacks to October of 2005. Because my phone has not stopped ringing, and it's just the confusion right now around student loans is just hysterical, and I mean that word deliberately. And so, if you can explain their student loans to a person, they'll pay you just for that, because nobody else has ever done that for them, and the servicers don't do it, and so they are so grateful. And they send their friends and their family to you. I mean, I'm a little bit too much of a softie sometimes, but this is not a one thing done kind of an engagement.
All right, we're going to do rapid fire. We've got 2 minutes to talk about the top 10 things you should be doing next. The pause on payments currently scheduled to end August 31st. Interest resumes September 1 and payments start October 2023. Many borrowers over the last 3.5 years have committed their student loan payment money to something else. The funds they were using to pay their student loans are now being paid towards additional food, groceries, utilities, car payments, increases in rent, mortgage expenses, etc. The idea of recommitting those funds to student loan payments is not something most people are relishing. So how do we help people? As an attorney, educate yourself about what's happening. Congratulations, you've been here today and you've done it. The materials can help as well. Review your past and existing clients for potential student loan assistance. If you want to start helping people, you can do that. Go look in your file, you've got tons of folks. Next, evaluate each new client for student loan issues and consider how you're going to handle new clients that have student loan questions. Are you comfortable doing some of it yourself? Do you want to refer some of it out? Again, Karen and I are happy to help. If you are interested in getting into this work, we're also happy to help. There are 45 million student loan borrowers. There's no shortage of clients. What should borrowers do? And I love this list. It's 10 things that borrowers need to keep track of. Make sure their updated address and emails are on file with their servicers and the Department of Education. Go to studentaid.gov, update their info. Review their loan information to determine whether the loans are in good standing or in default. If they're in default, get into Fresh Start as soon as possible. Consider whether they can benefit from a consolidation. I think we've hammered this enough times, but there's more details there just in case. 4, evaluate the number of payments the borrower has accumulated for purposes of PSLF, IDR forgiveness, and possible SAVE forgiveness. Remember, under the SAVE program, if their original loan balance was less than $20,000, they don't have to pay for 20 years. They may already be eligible, and you're going to get credit. Anyone who has made payments up to this point will get credit towards that SAVE forgiveness, same as IDR and PSLF. Use that estimator. Stanley's estimator is I'm not joking you, probably one of the best things I've seen in student loan world for a while. For borrowers who've been working for a public service employer, make sure that they're submitting their employer certification forms and that they have the right loan type. 6, evaluate the repayment options. Most borrowers will not have to recertify their income for income-driven purposes for at least 6 months. They may not want to because their income back in 2019 and 2020 was lower than it is now. So their payment will stay lower. If their income has gone down, they should recertify immediately so that they get a lower payment based on their lower income. IDR recertification, that's what I just said. Contact the servicers to re-enroll in automatic payments. If you enroll in automatic payments with your student loan servicer, you get an interest rate reduction. I think it's a 1/4 point. Is that right, Karen?
Yeah. Yes.
And that is great for borrowers who are intending to pay off the loan, or borrowers who maybe are in ICR or IBR. If you're not going to be in SAVE where you get that interest covered by the government, you might want to make sure you're getting that automatic rate reduction. Stay vigilant as the IDR recount is completed. Keep track of where you are. We are anticipating that there will be a whole nother wave of work to be done challenging IDR recount because the Department of Education doesn't have a great track record on getting all of this right. I expect we will have people who have their IDR recount that needs correction or amendment going forward. So keep vigilant about that. Number 10, make your payments. You've got to stay on top of the student loans from now on because the payment pause is done and we want people to get forgiveness. Evaluation tools, lots of really good tools. Federal student aid loan data is available at studentaid.gov. Once they have their NSLVS or text data, you can get the information about how to get that in the materials. Lots of great evaluation tools. Keep in mind, as an attorney, you cannot log into studentaid.gov with your client's credentials. That's not allowed. Department of Education, the rules about that are there. Have the client pull it. Good resources available. Federal Student Loan Ombudsman is awesome. Call us if you have questions. What are your questions? Anything we can answer.
Well, there's one more thing we should say, that Jubilee and Stretto and Josh Cohen all have programs that you can purchase to do some of the evaluation. And so you're going to be hearing about those. So do know that there are 3 current commercially available programs that will do some of the evaluation. You can't just turn this on and say it's going to kick out everything, but they are available.
That's absolutely true. Our contact information is on the last slides in here. If you're reaching out, just send us email, reach out by phone. Either of those are great. Last thing I will say is in the materials that you were emailed are the link for evaluation. We would be really grateful if you would fill out the evaluation. It'll take less than 3 minutes. It also, in that email, is the code for credit from the Colorado Attorney Regulation Department, CLE department. So you can go in and do your affidavit online. There's a link and the code. I'm not distributing handwritten anything. So if you have questions, if you didn't get the materials, please let me know. We will have this available for home studies. So if you know somebody that didn't get a chance to come today but are interested in seeing the program, I'll put up home study details as well. So that's it. Thank you all for coming. We really appreciate it.
Yeah, thank you.